For a limiting instruction to be given, please request it now.
Your Honor, I'm at a loss. I think that an instruction that, this doesn't show hatred towards Danny. So again, I'm not sure. Obviously disagree with the state's argument.
One thing, though, that is starting to trouble me with this, we had many motion hearings in this matter, and we've continued this case several times to handle these matters pre-trial. Why is this coming up now?
The exhibit that we were provided with, I went through thoroughly and had all of my objections listed, and then was told that's not correct. It's another binder. It's different emails. The binder I was handed by the state was completely discombobulated, not in date order. It was a train wreck.
As the state's exhibit you're referring to.
That's correct. And so then they provided us with this binder. It appears to maybe still be missing something, but they have a list, an exhibit list, everything laid out by date, by exhibit A, all the sub-exhibit numbers. So that's why, Your Honor.
We're not going to be wasting the jurors' times. At this point, we're 30 minutes behind where we should have been. Are there any other matters that need to be addressed?
There's one more that I asked for, Judge. It's dated April the 20th of 2016, and it's an email about whether one of the children is sad.
64II, Judge, is an email specifically in which the defendant is claiming that the child cannot be sad about the death of his father.
What is the undue prejudice that the defense is arguing concerning this particular email?
The undue prejudice is what the state is arguing, and they're going to argue to the jury, is that this email says that Donna Adelson said he could not be sad about his father. What she's describing as her time with the child, and she hasn't seen him sad.
All right. At this point, I'm nearing becoming inclined to send the jurors home for the day, as we are wasting a significant amount of time on matters that were either previously litigated or now are still being challenged for reasons that could have been handled out of court.
He is not happy with the defense. And he wasn't meaning for him to sit there and read it all right now. It's unbelievable.
Before we leave here today, if we need to go through every single state exhibit to deal with any objections concerning them, we will do so, however long that takes. But we're not going to be wasting the jurors' time.
He's doing a good job of controlling his feelings. I can just feel how annoyed he is. You have to have some nerve to go and start the trial, and you already brought up all these things and they already were ruled on, and yet you're just going to continue it in court? It was ruled on already.
Concerning that, Ms. Kappelman, between former Detective Eisen, Wendy Adelson, or any other witnesses, are you going to be establishing the foundation as to the defendant's knowledge or connection through multiple witnesses?
I had not planned to do that. I provided this exhibit to the defense. I had not heard anything about an objection, so I had not planned to go through every single piece of paper with this witness.
Are you requesting for me to send the jurors home for the day? Please bring the jurors up.
Dan
Objection, Your
Markel.
Honor.
What is the objection?
First of all, lack of foundation, and it's hearsay at this point.
Overruled as to lack of foundation. The investigator may testify as to his personal knowledge of the investigation.
Did Mrs. Adelson respond to this email?
Your Honor, then object again. Mrs.
One
Adelson.
moment. Members of the jury, the bailiff is going to take you out.
He told him that he can't do this and to make objections before they start up again. Oh my gosh, the judge is gonna kill him. Oh my gosh. he is gonna absolutely freak out. I think he's
So,
trying to reel
not
in
to sound like a
his
broken
feelings.
record, but that part where the jurors need to go home so the issues concerning these documents can be worked through, concerning that, Mr. Zellman, what is your position? I know what your argument is, but as to the items that the state is seeking to admit today, are there going to be more challenges of this nature? If you have objections, I will rule on them, but we're not going to waste the jurors' time.
Judge, as to 64AA, my client and her husband shared an email address. There's no evidence as to who sent the response that the state is trying to get to.
As far as to whom the email address belonged, that will have to be tied up with Wendy Adelson.
Well, is there any other parts of Exhibit 64 that need to be dealt with now while the jurors are out of the room? Please look through it. Are there any other exhibits that pertain to Detective Isom that need to be dealt with while the jurors are out of the room?
Would you like to know what items I intend to introduce, Judge, through him?
Please, so we can handle these objections now and there will not be a constant back and forth where the jurors need to leave the room. Please bring back in the jurors.